So the starting point for today's webinar tends to be the starting point for a lot of things in litigation, and that's the overriding objective. So a very quick recap. The first thing the CPR says at part 1.1 is that the court has a responsibility to deal with cases justly and at proportionate cost. And then it goes on to say at rule 1.12F that this includes enforcing compliance with rules, practice directions, and orders. And under CPR 3 and its inherent jurisdiction, the court has got really broad case management powers to achieve this. So, for example, when it's faced with a non-compliant party, it may decide to issue directions for the breach to be cured. It can make an adverse cost order to sanction unreasonable behaviour. Or, in the more extreme cases, it can go even further than that, and it can strike out some or all of a party's statement of case under CPR 3.42C. Or additionally, or alternatively, it could make a debarring order. So, given the very serious consequences of a debarring order, when would it be appropriate for a party to apply for one? In Michael Wilson and Partners and Sinclair, the claimant successfully applied for a debarring order on unless terms where the defendants had failed to pay costs orders totalling over £1.1 million. And we're going to come back to this case in a moment, but at this stage, it's just important to note that in the right circumstances, the courts will make debarring orders where the default relates to unpaid costs. Fifthly, where the defaulting party hasn't adduced proper evidence of their impecuniosity and doesn't appear to have sufficient assets in the jurisdiction, payment of the cost order is generally the price of being allowed to continue to participate in litigation. And then finally, and this is a point that we touched on earlier, where a debarring order is made, it should generally be made on unless terms, unless there are good reasons for imposing an immediate order.